There are no limits of time within which the rest gas stay can be arbitrarily confined. These limits vary in fact with each particular case. The acts of declarations are not required to be contemporaneous with the primary fact, but they must be so connected with it as to make the act or declaration and the main fact particularly inseparable or be generated by an excited feeling which extends without break or let down from the moment of the event they illustrate. In other words, if the acts or declarations sprang out of the part of the principal transaction, trends to explain it were voluntary and spontaneous and were made at the time so near it as so preclude the idea of deliberate design. They may be regarded as contemporaneous in point of time and are admissible. In People versus Sanchez, this court had occasion to state that the cases are not uniform. As to the interval of time that should separate the occurrence of the startling event and the making of the declaration, what is important is the declarations were voluntarily and spontaneous made, so nearly contemporaneous as to be in the presence of the transaction, which they illustrate or explain, and were made under such circumstances as necessarily to exclude the ideas of design or deliberation. As to the second factor, it may be stressed that a statement made or an act done at the place some distance from the place where the principal transaction occurred will not ordinarily possess such spontaneity as would render it admissible. And the third factor, A. Statement will not ordinarily be deemed spontaneous if at the time when it was made. The conditions of the declarant was such as to raise an inference that the effect of the occurrence on the mind still continued, as where he had just received a serious injury, was suffering severe pain, or was under intense excitement. Conversely, a lack of spontaneity may be inferred from the cool demeanor or declarant. His consciousness of the absence of all danger. His delay in making a statement until witness can be procured, or from the fact that he made a different statement prior to the one which is offered in evidence. The last factor need no further elaboration. Emphasize supplied. Guided by the foregoing standards, the court finds the CA and RTC correctly considered the statements of AAA as part as the Resgache Olideles.
In the case at bar, AAA went to and arrived at the house of her aunt E by noon of April 16, 2001, about 12 hours after she was raped by her father. She left her house that day after she was raped 3 times by her own father and went to her aunt's house located in the same municipality. Upon arrival at her aunt's house, AAA was sad and crying and revealed to her aunt that she was raped by her father. Although her uterance may not have been made immediately or simultaneous when the actual rape, the said uterines were so connected with it as to make the act or declaration in the main fact inseparable or be generated by an excited feeling which extend without break or let down from the moment of the event they illustrate. On this factual backdrop, it is clearly evident that AM made this revelation to her aunt before she could make a deliberate design or had the opportunity to devise for contrive anything contrary to the real facts that occurred. Next. Next. Apply the rule in People vs. Sanchez. The court finds that AA revolution to her aunt about 12 hours after she was raped. The voluntarily and spontaneously made so nearly contemporaneous as to be in the presence of the transaction which they illustrate or explain, and were made under such circumstances to include the idea of design or deliberation. When AA arrived at her house aunt house in Barangay Bandana of the same municipality where AA lived in Barangay Manugtong, she must have walked the whole morning considering that according to her aunt, when is one walking for the house of AAA, one will arrive at her house by noon time. Next, notwithstanding that foregoing that court finds that the critical elements or carnal knowledge through force was sufficiently established by the evidence or record. The clear and straightforward testimony of E, together with the medical legal findings, consist with the facts described, produced, or convention beyond reasonable doubt that X is guilty from the repeated defilement of her own daughter, AAA. Next, Romo.
Dialogo, ikaw na.
Romo.
In in numerous occasions, the court has held that in the absence of facts and circumstances of weight and substance that would affect the result of case, affiliate courts will review the trial court cogent reason to reverse the RTC appreciation of the evidence, which was affirmed in toto by the CA. Next. Next. Next pre. Shal. That XXX guilt was proven behind reasonable doubt by the evidence of the prosecution. In criminal cases, proof behind reasonable doubt does not mean such degree of proof, excluding possibility of error, that produces absolute certainty. Only moral certainty is required, or that degree of proof which produces conviction in an prejudiced mind. Anent the penalty, the court accordingly modifies that award of damage to comport prevailing jurisprudence. Next. Whereof, in the view of the foregoing, the appeal is dismissed for lack of merit, and the decision dated April 9, 2012 of the Court of Appeals Cebu in CRHC number 00332 is hereby affirmed with modification. Accused appellant XXX is hereby found guilty behind reasonable doubt of 3 counts of rape as defined under paragraph 1, article 266A of the revised penal code as amended, and hereby sentenced to Next. The amount of damage awarded is hereby increased, or during accused appellant to pay the heirs of AA the amount of 75,000 pesos, a civil indemnity, 75,000 pesos as a moral damage, and 75,000 pesos as exemplary damage for each count of rape in criminal case number F2001-171A at F0202A, F2001-170A. All monetary awards shall be earned interest at the legal rate of 6% per annum from the date of penalty this decision until fully paid, so ordered.
Thank you, sir. Thank you sa mga kagrupo ko. Dito na po matatapos yung
Thank
report.
you, sir.